Good afternoon. It's my great pleasure. Are we live? I think we're live. It's my great pleasure to introduce this panel. Let me first start with housekeeping that we are accredited for CLE, and our CLE code is 432581. And there on the landing page, there is a CLE affirmation form which you need to submit by November 6th. Repeating, it is 432581. So it's my great pleasure to chair this panel on behalf of the ICC Committee of the American Branch of the International Law Association. I'm very, very pleased to have these very distinguished panelists. They have each very lengthy bios, so I will only give you the very short version. I welcome Harold H. Koh. He's the former legal advisor at the U.S. Department of State and currently Sterling Professor of International Law, Yale Law School. Ambassador Clint Williamson is former U.S. Ambassador at Large for War Crimes Issues and currently Senior Director for International Rule of Law, Governance, and Security at the McCain Institute. Ambassador Stephen J. Rapp is former U.S. Ambassador at Large for War Crimes Issues and former Head of the Office of Global Criminal Justice at the U.S. Department of State and currently Senior Visiting Fellow at the Blavatnik School at Oxford University. Beth van Schaack is former Deputy to the Ambassador at Large for War Crimes Issues, Office of Global Criminal Justice at the U.S. Department of State, and currently Leah Kaplan, Visiting Professor at Human Rights, Stanford Law School. So our panel today is going to focus on the U.S. International Criminal Court relationship, and particularly the June 11, 2020 executive order allowing the impositions of sanctions against ICC staff and more broadly, and the subsequent imposition of those sanctions. I'm going to provide a little bit of background on the US-ICC relationship and a little bit on the executive order, and then have a series of questions for our panelists. To the audience, if you would like to write your questions in the Q&A function, I'll try to save 10 minutes at the end for those questions. So the audience may know that the US has fluctuated in its relationship to the International Criminal Court. Under the Clinton administration, the US sent a negotiating team to Rome headed by David Schaffer, who became the US first war crimes ambassador, with US signing the Rome Statute, but even then noting it did not intend to become a state party. Under the Bush administration, particularly the first term, and I emphasize first term, recognizing that Ambassador Williamson was war crimes ambassador in the second term, but so the hostility manifested most in the first term with 4 steps: the purported unsigning of the Rome Statute. I do my air quotes because the Vienna Convention on the Law of Treaties does not allow for unsigning, so one might not actually call it even an unsigning, but the intent was clear. Passage of the American Service Member Protection Act, bilateral agreements trying to get other countries to agree never to surrender a US national to the court, and passage of 2 Security Council resolutions, one resolution and its renewal that exempted from ICC prosecution current or former officials or personnel from a state's party, not parties to the Rome Statute, who were involved in peacekeeping operations. During the second term, this hostility moderated, and we do have referral of the Darfur situation to the ICC with the US abstention. Under the Obama administration, I'll only say 2 words because we have 3 of their representatives on our panel today. The US had what could be said to be a constructive relationship, engaging on a case-by-case basis and actually assisting in certain of the situations. The current administration's approach is absolutely the most hostile the US has been. So it initially started with a series of anti-ICC statements by US National Security Advisor John Bolton, then National Security Advisor John Bolton, the US President, and the Secretary of State Pompeo. These mainly focused on the investigation related to Afghanistan, with a secondary focus concerned whether the Israel-Palestine preliminary examination would move forward. As to the Afghanistan situation, the court has been looking at the conduct of the Taliban and affiliated forces, the Afghan military, as well as US members of the CIA and DOD alleged to be implicated in torture and related crimes occurring both in Afghanistan, which is a Rome Statute state party, therefore creating jurisdiction over this, as well as some related conduct thought to have occurred in Poland, Romania, and Lithuania, which are also Rome Statute state parties. The prosecutor had requested for permission to proceed with the Afghanistan investigation. The pretrial chamber 2 originally denied her request, after this went up on appeal, and there were amicus briefs, and Ambassador Schaffer, who spoke in the plenary session of International Law Weekend, as well as Ambassador Rapp and I, along with many others, filed amicus briefs arguing for a reversal of the pretrial chamber's decision, and this did subsequently occur in the opening of the investigation. Following that, we had threats of sanctions, and then the June 11 executive order allowing for the imposition of sanctions, specifically asset freezes and travel bans. These have been now implemented, as far as we know, against at least two ICC officials, Prosecutor Fatou Bensouda and head of the Jurisdiction, Complementarity and Cooperation Division, the JCCD, at the ICC OTP, Fakiso Mochochoko. So with that background, let me turn to the panelists to ask questions. And I'm going to start with Stephen on this one, and then turning to Beth. So the executive order characterized the ICC and its investigation into the situation in Afghanistan as an unusual and extraordinary threat to national security and foreign policy of the United States, which created a national emergency. Do you believe the ICC poses such a threat to the US? And is the executive's power so broad under the International Emergency Economic Powers Act that virtually anything could be designated? And just to note, this designation somewhat conflicts with statements made by Secretary of State Pompeo at the very date of the executive order's issuance, where he characterized the ICC as a weak and ineffectual institution. So is it a weak and ineffectual institution, or a national security risk, or maybe something in between? Stephen.
To unmute, it is not a national security threat to the United States, nor really even a foreign policy threat to the United States, and certainly not an emergency. There are ways to deal with the ICC. We did during the Obama administration by engaging in the room. The answer to Afghanistan is to show that we held our own people to account, that we had processes in the Senate, that we had a special counsel in the Justice Department. I think we need to go a little further than that, frankly. But that's the way to resolve it, and that's a matter of just dealing with the issue illegally. On Palestine, obviously, people are very concerned about Israel's security, certainly, but they haven't opened the case yet. It's not a situation where there's even an investigation, and there's this big jurisdictional question. And so you mentioned I filed an amicus on one side on the Afghanistan case. Todd Buchwald, who succeeded me as ambassador at large, both during the Obama and Trump administrations, has joined me in a brief questioning the jurisdiction of the ICC over Palestine, Palestine not yet being a state that could delegate its criminal jurisdiction to the ICC. And a number of other states like Germany and Australia have also filed amicus briefs. There are ways to deal with the ICC and to engage on the basis of the law. You don't threaten the court, you don't threaten judges, you operate under a statute, and you particularly don't threaten the court that's has every country in NATO except Turkey as a member, every country in South America as a member, almost all our key allies. And they're all opposing us on this. They've demarched us on it. They've raised this as an outrageous thing to do. So it really is unfortunate. There was one thing that I do think it's important to add, that this IEPA, which may be overused, this Emergency Act, it's the way that we actually implement sanctions when the UN orders them, for instance, as has happened in the past in situations like North Korea, for instance, or in Congo or in Liberia. And we use it for that purpose because of the threat to international peace and security that's represented there. And we use it now for Magnitsky sanctions and other things, and in places where the UN won't go, like Syria, where poison gas is used and hospitals are attacked and hundreds of thousands are tortured to death. And it's important that people, when we do these sanctions under IEPA, comply with them and that we can enforce them. But when we go off the reservation like we have with this ICC thing, we're undermining our ability to enforce sanctions when we need to. And countries will stop using the New York financial hub. They'll stop coming here. They'll use another currency. And we'll find that we don't even have a tool to use when we really do face a threat to our national security and our foreign policy. But the Russians and Chinese won't go along in the Security Council, for instance. We need to do it unilaterally, through our own law. So it really is shooting ourselves in the foot. And there's so much better ways to deal with it. And it's ludicrous to say national security threat from this indeed relatively weak court in The Hague.
Beth, do you want to add to Stephen's remarks?
Sure. Well, I'm largely in agreement in the fact that by overextending the use of this tool, which we usually deploy against drug kingpins and terrorist networks and warlords and human rights abusers and adversarial regimes, we're really potentially weakening this by overextending into this really inappropriate context. It's really perverse to see it applied against international civil servants whose mandate is to prosecute the most serious crimes known to humankind. And I think nobody doubts that rogue regimes around the world are going to use this US approach as a model and as justification to harass their own domestic prosecutors and judges when they would seek to prosecute government actors for corruption or abuses of power or human rights abuses. Now, you asked about how this might be received within US courts. Historically, courts have been quite deferential to presidential national security determinations like this. But I think there is a question as to whether or not the judiciary will be willing to go along in the face of such a dramatic and controversial and unprecedented use of IEPA. And we may get into this later, but there already has been one lawsuit filed on behalf of 4 dual nationals who have done work with the court and feel that they're at risk, both from the perspective of being potentially sanctioned themselves by virtue of their foreign nationalities, but also subject to an enforcement action against them by virtue of their US citizenship. And they have sort of fallen within a safe harbor that allows for certain free speech and assembly conduct that falls outside of the sanctions regime given our First Amendment protections. Now, I think we have to be careful about not understating the perceived threat here. Obviously, the prospects of an investigation against former US officials for the program of detainee torture will be seen in some elements of the US government as really an acute threat. And it's unlikely, although Secretary of State Pompeo often speaks about, our men and women in uniform, I think it's more likely that if a case were to go forward, it would involve someone higher up the chain of command. And so that's obviously going to be perceived of as an acute threat to those agencies. But as Ambassador Rapp said, this particular response is profoundly counterproductive, and it overlooks and even renders much more difficult to utilize other more effective responses, particularly diplomacy, not just with actors within the court, but also our allies, who I think many of whom are in agreement that the court's aperture is too wide, it's taking on too much, it's taking on too many politically controversial issues and failing on the sort of easy cases that it should be really focusing its investigative and judicial energies on. Many states' parties are disappointed by the working methods and some of the output of the OTP and of chambers. And there's been this review process underway. And many of the proposals that are being bounced around, I think, are quite consistent with where US interests would be here. And yet, I think by taking this really strong stand, it potentially weakens the ability of states' parties to make some of these arguments, because it will look like either they're doing the bidding of the United States or the court or the ASP is somehow cowing to US pressure. And so, as Stephen said, it's really profoundly counterproductive to take this route, because it forecloses other more effective avenues that we might have available to us to address these two situations.
I don't know if Clint or Harold want to quickly weigh in on this one, or I will move on to my next question. Yeah, Harold, please. You have to unmute yourself.
The last point that Beth and Steve made is, I think, the most important. I think we have to be frank that the chance of this being struck down in court are low. The Supreme Court and Regan versus Wald gave extreme deference to a declaration of a national emergency under IEPA. And more than that, later on in Beacon Products case, a court held that it was a political question even to examine whether there are a national emergency. And Trump has invoked national emergencies all over the place, including the claim that he needed to use executive funds to build a wall because the national emergency was that Congress hadn't appropriated money for it. So I think the chance of getting a win through the courts are pretty low. And I think you have to acknowledge that. I think the point that Beth and Steve made is much more that the negative effects of this have been felt almost immediately. Nobody went along with the US proposal for Iran's snapback sanctions, partly because this was viewed as an abuse. The Trump administration has engaged in massive overuse of sanctions. I think Steve pointed to an extremely important element, which is that if they shift funds into the euro and out of US as the currency of choice, so that this will have a long-term effect on New York as a banking capital. It's driven Iran together with China in combating these sanctions. And it's driven a wedge between the United States and the EU. And all of these things are extremely harmful to our foreign policy in the long term.
Clint, do you want to weigh in on this one, or shall I head to the next question? Okay. So just to be clear, so the lawsuit that Beth referred to actually doesn't bring the IEPA challenge. So it doesn't say there was no power, but it more focused on the breadth of the executive order. So that's going to be my next question to Beth. It's about the breadth of the order. And just to state for purposes of the audience, the order covers persons engaged in an effort by the ICC to investigate, arrest, detain, or prosecute any US personnel without US consent. So that's related to the Afghanistan investigation, as well as the same regarding any country that is a US ally without the consent of that country. And given statements by Secretary of State Pompeo, we think this is primarily aimed at moving forward related to Israel. Or anyone who materially assisted, and I should say this applies to foreign persons, sponsored or provided support for goods or services to anyone related to the two categories I just said, or regarding US or foreign nationals if you provide funds, goods, or any services for the benefit of the person whose property has been blocked. So that would be the prosecutor. And it provides travel bans for family members of persons who have been designated. So Beth, what are your views on the breadth of the order?
Yeah, it's extremely problematic. And this is one of the pillars of the lawsuit that was filed, in addition to making the sort of First Amendment arguments around freedom of speech and assembly with respect to the provision of information, which is an amendment to IEPA that allows for these sort of First Amendment safe harbor protections. A second concern is the Fifth Amendment due process concern, the idea that this is so overbroad that it gives no notice at all as to what sort of conduct might be subject to an enforcement action, particularly vis-a-vis US persons who, as you mentioned, can't be designated for sanctions, but can be enforced against in both the civil and the criminal context if they provide some sort of material assistance. And so we're already seeing a number of smaller NGOs, academics, academic centers, human rights clinics, NGOs, activists, et cetera, who are feeling chilled in their activity. And many of them are working well outside of the Afghanistan situation, but because the prosecutor herself has been designated, anything that might be seen as materially assisting in her work could potentially open them up to enforcement measures. And so as a result, we're seeing an infringement and a chilling of international justice efforts around the globe in areas where the United States actually supports justice and accountability. So thinking about the Rohingya, thinking about some of the Central African matters that are open for investigation, the United States has long supported justice and accountability in those measures, has supported local courts, regional courts, special courts, and also the work of the ICC in those matters. And so the overbreadth is a real problem, and maybe one area where this lawsuit might be able to trigger some sort of a response that would clarify when enforcement actions will be taken under the executive order.
Thank you. I don't know if any of the other panelists want to weigh in on the overbreadth question.
Well, just from a policy standpoint, I mean, and leaving aside the cases of the four plaintiffs who are dual nationals, and they could get designated together with Fatu and Fakizo, and of course that designation takes some participation or something having to do with the Afghanistan and Palestine cases. But when it comes to then dealing with the prosecutor of the ICC or with their head of their diplomatic office, it seems to me that they're SDNs, they're specially designated individuals, and any of us that deal with them and help them in any way, even on things that we care about, like bringing Bashir to The Hague, we could be in trouble. I'm scheduled to be on a forum with in person, a small group in Geneva in 2 weeks with Fatou Bensouda about UN documentation and these new mechanisms. And obviously, in some situations like Libya and other places, that could help the ICC. So I say, yeah, that can help the ICC. Am I, and say, good point, Fatou. I don't think I'm going to get prosecuted and face 20 years in jail under it, but you really chill this opportunity for Americans to engage consistent with our values and trying to bring Bashir to justice, or trying to bring the war criminals that have torn up Libya and attacked Americans and others to justice. We undermine our position and we prevent others that might not be so bold from even being in the same room with these folks.
I don't know if Clint or Harold want to weigh in on the overbreath.
Well, again, I think we want to distinguish between what would be a correct interpretation of the law and what this Supreme Court would likely hold. I mean, in Humanitarian Law Project against Holder, a less conservative court upheld comparably broad chilling effects on NGOs. And if by some good fortune they were able to get a preliminary injunction, this Solicitor General's office has no trouble taking these cases directly to the Supreme Court for a stay without even a review at the Court of Appeals. So the better approach here is to vote this administration out of office in 11 days and get this repaired politically. And I think the purpose of the lawsuit is obviously to get attention to this issue and put pressure on the next administration to give it a high priority. But I think to actually push it through the courts could end up with a negative precedent.
Clint, do you want to weigh in on this one? You're muted still. But I think that was a no. Did you want to weigh in on this one? You were muted.
No, it was a no. I was just
okay, sorry.
And I apologize. I'm having some problems with my internet, so hopefully it holds when I do start speaking.
All right, so I'll move to the next question. So the US historically has played a leading role in the field of international justice. It led the prosecutions at the Nuremberg Tribunal, the Tokyo Tribunal, played a strong role in the Yugoslav and Rwanda tribunals with Ambassador Williamson, the first US prosecutor to arrive at the ICTY. Ambassador Rapp led the prosecutions of the media trial. At the Sierra Leone Special Court, 3 of the 4 chief prosecutors, including Steve Rapp, were US nationals, and the residual prosecutor currently is US national. At the Cambodia Tribunal, the 3rd and 4th international co-prosecutors have been US nationals, and Ambassador Williamson and Sheffer were the UN Secretary General Special Assistant on UN assistance to the tribunal. Ambassador Williamson was chief prosecutor for the EU Special Investigative Task Force, which was predecessor to the Kosovo Specialist Chambers, which then had an American prosecutor, now has an American prosecutor, and earlier we heard from Alex Whiting, who is the deputy prosecutor there. So given all this tremendous history of support for the field of international justice, is it not hypocritical for the US to attempt to block justice when the spotlight is shown on alleged crimes related to US nationals? And I'll turn to Clint.
Yeah, absolutely, it's hypocritical. And it undermines US credibility. I mean, you cited the recent history of US engagement and support for international criminal justice, but the US leadership goes back much further than that. Not only in terms of what we're doing now, but it's a betrayal of our strong legacy on these issues for over 150 years. The US was always in the forefront of efforts to advance international humanitarian law from the middle of the 19th century forward. All the instances you've talked about in the 20th century where we've been so engaged. Stephen and I have worked directly in various tribunals. When I was on secondment to the ICTY, back in the 1990s, Harold was in a senior role at the State Department working on these issues. When I was in the role with the Kosovo court, Beth was Stephen's deputy, and I worked very closely with her there. So the level of US engagement and leadership in the modern area of international justice has been unsurpassed, I would say. And as I've just indicated, it's an undertaking in which all of us on this panel have been involved in a very personal way. So I don't want to speak for my colleagues, but I think we all feel in the Trump administration's actions a sense of betrayal to a legacy that we have all helped shape over the years. You know, I spent 7 years at the ICTY and then another year at the UN mission in Kosovo before I was recalled to Washington by the Justice Department. And I was posted to the White House on the National Security Council staff at that time. So this was in 2003. And my assignment at the White House coincided with John Bolton's campaign against the ICC that you mentioned a moment ago in the first term of the Bush administration. And particularly the very prominent use of these Article 98 agreements, the bilateral agreements to not hand over American personnel for prosecution. And because I had spent all this time at ICTY, this was not my portfolio at the NSC, but I got pulled into a lot of these discussions. And Condoleezza Rice, who was then the National Security Advisor, was very troubled by this and the damage that she saw this policy doing to US national interests. And she totally bought into the argument that I was making, that this was incredibly hypocritical at that time for us to go in, for example, and press Serbia and Croatia to turn over indictees to the ICTY, and then in the next breath, put in front of them an Article 98 agreement asking them to commit to not handing over Americans for prosecution. So she was troubled by the hypocrisy of this policy. And when she became Secretary of State, she sought to reverse a lot of these things. But I think what's different right now is we don't see any senior political appointees in this current administration having any misgivings at all about this policy approach. Instead, they've embraced a unilateralist view that promotes US interests above all others and without regard for the consequences. Look, every state puts its own national interest first. So the US is not unique in that regard. But because of its political, economic, and military weight, when the US does do that, it tends to have more far-reaching implications for the international order. And where prior administrations have generally tried to balance those interests, perhaps not as much as everyone would like, they have at least over time made an effort to square US policies with the US role in the global order. And they've made attempts, again, not always successfully, to mitigate charges of US hypocrisy. But this is the first administration in my lifetime, at least, that has totally rejected the need to do that. And as a result, it damages US credibility. But because of the outsized role that the US plays in world affairs, it also undermines the international order and it encourages others to flout the rules. So yes, it's very troubling.
Stephen, did you want to weigh in on this one?
I would like to. I mean, you mentioned, Jennifer, the things the United States had done during our constructive or positive engagement during the Obama administration. And they were considerable. We did have this American Service Members Protection Act, the famous Invade the Hague Act, but it did include an amendment by Senator Dodd that allowed us to assist an international court on a case-by-case basis if there were non-citizens charged with genocide, war crimes, or crimes against humanity. And we used that, frankly, and determined that every case that the ICC was involved in at the time, that had actually gone to the investigative stage, was one that we supported. And we even were successful in persuading the Congress to expand our Rewards for Justice program, under which I paid 14 rewards for Yugoslavia and Rwanda fugitives, to include the ICC if we gave notice to Congress. And that announcement and other political factors and leverage that we used helped bring Bosco Ntaganda to our embassy, where he surrendered, and we brought him to The Hague. I'm going to our contingent in the Counter Coney operation in the Central African Republic, where we then even flew him on a U.S. military aircraft 800 kilometers from Obo to Bangui to get on a flight to The Hague, where he stood trial. Each of these were good, strong cases, people that were alleged and proven to have committed horrible crimes against innocent men, women, and children. And these were consistent with our values. And And of course, what the United States has often done in these courts, of course, we were dues-paying members of the UN and we were contributing members to the voluntary funds that supported other courts. We're not contributing any money to the ICC. But frankly, it's more than money to make these courts succeed. They need a diplomatic leverage like we used to get Milosevic to the ICTY or Taylor to the Special Court for Sierra Leone. They need intelligence and information sharing and assistance on fugitives. And we were doing that. And that was putting us in the room. And so when there were issues between us and the ICC, we were much more persuasive. Of course, we'd always have the issue when we went out. I remember when we were arguing that Bashir should be arrested in South Africa, and South Africans said, well, listen to you when you join the ICC. And my argument to that was, well, look, we're committed to trying our own people, and we'll always have a tough system of justice to hold American war criminals to account, and we'll never give reason for the ICC, which is a court of last resort, to even look at us. And now, unfortunately, under this administration, with pardons of people that the military justice system has had strong cases against, and no real effort to show that we've had accountability on torture, even though there were some efforts in that direction, we've really weakened that kind of argument and made ourselves much less effective when we're dealing with the Assads or the crimes committed by the Chinese or in Venezuela or elsewhere. Who's going to listen to us? And so that's what really bothers me about the approach that we're taking. We can engage, we can constructively work through these issues, and doing it the way this administration is doing is contrary to our values, and as I said before, counterproductive.
I don't know if Beth or Harold want to weigh in on this question, kind of the hypocrisy based on Harold.
I would go big picture and less focus on the obvious hypocrisy and more on the long-term counterproductivity of what's going on. So first of all, this International Law Weekend, I mean, what's happening with regard to the ICC is happening with regard to the WHO, it's happening with regard to the Paris Climate Agreement, it's happening with regard to the WTO. So the ICC is obviously the most extreme case, but it's just an example of a completely defective foreign policy across the board with regard to multilateral institutions. Secondly, it shows that the approach of the administration is entirely transactional. There's no concept of relationships that can be sustained and built over time. And then third, when you think about what should be the thought, the long-term goal of the US toward the ICC and all these other organizations should be maintaining US engagement for a win-win proposition that the United States is better off because working through that organization serves our long-term interests. And it maintains US credibility with that organization. And the real danger is that if we have this on again, off again approach, we can't build the kind of consistency that's necessary for these institutions to become very much suffused with American expertise. And we have a lot of expertise, as you've seen these other tribunals. The latest incident, which is the one that has just occurred, blocks out a long history of positive relationships, as you say. So we shift from a win-win posture to a lose-lose, because the less that we're engaged with these organizations, the more they're likely to develop an adversarial relationship. The less worried they'll be about pursuing cases against us or not listening to the United States in these circumstances. And that's the vicious cycle that a Biden administration would have to focus on breaking to maintain some sense that working with the ICC on common interests, and there are many, ought to be the long-term objective.
That's a very good segue to our next question, which I'll turn to Harold for. If you were in a position to advise the new administration on what its policy should be towards the ICC, what advice would you provide?
Yeah, we want a strong ICC with good judges, good prosecutors, pursuing the most egregious cases, and with the United States supporting that activity, because if we do so, if the United States stays on the right side of history, which it should, it'll be in the United States' long-term interest. That's exactly why the US did Nuremberg, it was involved with Nuremberg and Tokyo and the ICTY and the ICTR. Now, I think the problem is that the advocates of international criminal justice in the US government or in the US Senate have declined over time. Very, very few people are actually ready to fight for that anymore, particularly after Chris Dodd, whose father was a prosecutor, left. You rarely hear people, even the Democrats in the Senate, supporting the International Criminal Court. And so I think a new administration would have to work its way back within the constraints of the law. And Steve and Beth and I were all there before. To me, it's like, without changing the law, to reverse the policy, which is a little bit like turning a car around inside your garage without breaking down any walls. It takes a lot of time and it's very difficult. But I think a new administration should focus first on getting rid of these totally counterproductive sanctions, and then developing a much more cooperative position over a year's time. I think an opportunity is presented by the election of the new prosecutor in December of this year. And that's an occasion for, the sanctions against Fatou Bensouda are ridiculous, but her time is running out. And if a new administration were able to engage with a new prosecutor and have much better lines of communication, that could be the beginning of the start of something better.
Clint, do you want to add to this one?
Yeah, I mean, as I mentioned a moment ago, we've been down this road before. It's, what has happened under this administration is more egregious than what happened even sort of in Bolton's scorched earth approach in the first term of the Bush administration, and it sort of pales in comparison now. But I think the point that Harold made is a valid one. There are very few champions on the Hill right now, or in terms of American public opinion, that are willing to stand up for the court. And that battle got to be even tougher because of the context in which we're operating with the Afghanistan and Israel-Palestine investigations. So I'm not sure that even if you have a Biden administration that is favorably inclined toward the court, that it is going to be able to go as far as we went under the Obama administration. But looking back to what happened in the second term of the Bush administration, as I said, Condi Rice, when she became Secretary of State, was interested in trying to undo some of the damage from the first term. And when I was nominated to be ambassador in 2006, the first point she made to me was, this should be a priority for you. And so there are certain things that I think we can do based on lessons learned from that period. Harold mentioned first thing is getting rid of sanctions, and I absolutely agree. One of the things that we did back in that time in 2006 was to stop this idea of pursuing the Article 98 agreements. I mean, the agreements were still in place, but just stopping, going out and pressing countries to do this had a huge symbolic effect. By rescinding this executive order with the sanctions on day one will have a similar effect. It will send a message that things have changed. Otherwise, it's approaching it in much the same way, trying to seek what Javier Solana had urged in his role as EU High Representative for Foreign Policy at the time, was to strike or forge a modus vivendi between the US and the ICC, where we would effectively agree to disagree on certain issues, but still to have a working relationship. And this is what I started working on in the Bush administration, meeting with the prosecutor, meeting with the president, having regular contacts with the court. We tried to shift things to a more favorable approach in international fora, particularly the UN Security Council, and we're able to do that over time. Helping to just cooperate with the ICC in terms of its investigations, things like that. In the Bush administration, I will say this, there was no administration-wide consensus on doing these things. So this was largely a policy that was kind of a personal policy of Secretary Rice centered in the State Department. And one of the first meetings that I attended, I stayed on as ambassador through much of the first year of the Obama administration. And one of the first meetings that we had on ICC policy, and I think Harold was there as well, And it started off with Samantha Power, who was chairing it, asking me, you know, can you just tell us some of the things that you were doing in the last couple of years of the Bush administration? And I started going through these things. And some of the people in the room were just thunderstruck because they had been unaware that this was going on. And a lot of them were career people who were saying, wait a minute, you weren't allowed to do that. You shouldn't have been doing that. So, you know, I don't think we should underestimate the opposition that may be out there, even from quarters that you wouldn't necessarily expect opposition to come from. But as I said, in the context of the Afghanistan investigation, in the context of Israel-Palestine, there are going to be people that are going to be, you know, intractably opposed to any sort of rapprochement with the ICC. But I think it's going to be incremental. But as I said, starting off by rescinding the executive order on day one would at least send a signal and would create an opening for then trying to do some of the things that were done incrementally in the Bush administration and much more robustly in the Obama administration.
I don't know if Beth or Stephen want to weigh in on this last one.
No, I would weigh in. Just as Harold said earlier, I do think that with these lawsuits, the Biden administration won't want to defend the lawsuit. So I'm hopeful that the executive order will be gone. But the issue of the positive engagement and bringing back to it, I know will be challenging. I mean, I think we should go there, but obviously people will say, what about Afghanistan? What are they going to do? And of course, the way to approach it now would be to file in the court and say, under Article 19, and say, we have a case. We're doing it ourselves. We're proceeding with accountability. We've done this and this and this and this. Obviously, that would run counter to those who present what I consider to be a useless argument that the ICC has no jurisdiction over us because we're not in the treaty. We're in this because Afghanistan is in the ICC, and it sent its territorial jurisdiction to the ICC. That's not affected by its SOFA or Article 98 or anything else. The crime that's committed on its territory is now at the ICC if it's one of those crimes, and there's no genuine process, and it's sufficiently grave. And when we try to make that argument, our Canadian friends say, hey, if we murder somebody in Toronto, it's not up to us where we send you to trial. No, that argument doesn't work. But you know, there'd be those who wouldn't even want to file something. They want to just say, we don't want to put anything in court. But I think, frankly, we should work with Afghanistan and others, and who obviously would like to defer the case and make a presentation, but at the same time, engage actively on the justice front and fill the gaps and actually show what has been done. I mean, Eric Holder talked about the Durham investigation and said that Durham really did try very hard to put a case together on torture, but in the end couldn't prove cause of death. And so there are arguments that can be presented that we've never frankly presented very clearly and with proper documentation and knock this down. And that's the way you deal with the judicial process. And then you go forward and encourage the court to go after situations where it can have an impact and where everybody in the world agrees that there are mass crimes and no justice happening, and the ICC or an international court is needed because otherwise there's no justice at all for the victims.
Just two quick points from my side, mainly to echo some of what others have said before. But number one is that issues of justice and accountability are very clearly bipartisan issues. Congress cares about these issues. And if you look at the Elie Wiesel Act, if you look at the Syria Accountability Act, strong bipartisan support, these pieces of legislation are passing with a lot of interest on both sides. And so I think a lot of work could be done to build a better relationship between Congress and the ICC, which is part of a system of international justice, and often the only actor that is able to move forward. And we saw this in the Darfur matter. Ambassador Williamson mentioned this, that it was really finally a recognition that that was going to be the only opportunity for those victims to have justice was before the ICC. And so the US got on board, and President Bush cared deeply about the prospects of genocide unfolding, and in fact made a genocide determination through a formal empirical process. So I think Congress can be better engaged, and whether that involves taking delegations to The Hague, bringing delegations from the court to the United States, much more information sharing, just having a better understanding of how these institutions operate and how they can have shared interests. The second point I would make is one raised by Ambassador Rapp concerning the question of complementarity. And I think there's a broad-based recognition within the academic community and now increasingly the diplomatic and juridical community that the way in which the court is dealing with complementarity is really not what was originally envisioned by the drafters about the very idea, where it was a much more deferential approach. And the court has landed on a sort of same person, same conduct test. And so if the United States can't show that every person that might have been involved in a custodial abuse or in creating a system of extraordinary rendition to torture has been prosecuted, then automatically the ICC should have full jurisdiction. And I think there's a recognition that the court should be, well, number one, more deferential to non-state parties, right, who have not signed up to the court. To be sure, as Stephen said, if nationals commit crimes on non-state party territory, that falls within the jurisdiction of the court, but non-state parties have not bought into the concept of complementarity and have no cooperation obligations towards the court. So the onus is really on the prosecutor to prove that whatever system of accountability was put in place was insufficient. And there's also this recognition, I think, that we should be looking in a more gestalt way at the entire system of justice. What sort of measures were taken? Was there legal reform, promises and reforms that will protect against repetition? Was there systemic investigative approach that happened? The Detainee Treatment Act, for example, being passed, regulations changed within the DoD and the Central Intelligence Agency, looking more fully at how the system responded rather than necessarily kind of counting cases. It may be appropriate to take a more gestalt approach, particularly when we're dealing with non-state parties that, as I mentioned earlier, really aren't under any obligation to participate in a complementarity regime. Now, that is not to say that we should not respond to any movement against a US personnel in a defensive way. We will take a defensive posture, but we must do it within the context of the Rome Statute system, the rule of law, and also consistent with our values around judicial independence and promoting the rule of law more generally.
Does anyone want to weigh in maybe on before we go to audience questions, which I'm about to, on the notion of complementarity? Stephen made it pretty clear he thinks the US has not done it. And Beth, I don't know if same person, same conduct would apply when we're dealing with large scale crimes. Like, I don't think we have clarity. Yes, on an individual case, we use that test. So this is kind of a different situation. Any views? Some people have said the US has done complementarity. They looked at CIA torture. Lo and behold, they just found, nothing had to be prosecuted. And, therefore complementarity has been met. I mean, I've heard this argument made. It's not one I buy into. Anyone else? Last thoughts on complementarity? Harold.
Well, not just about complementarity, but a general statement to the audience. Even if a Biden administration comes in, it's going to need some time to get this right, and people should be patient. In that, first of all, you didn't hear the ICC mentioned last night in the debate or any of the debates. The four priorities for a Biden administration are climate, the pandemic, economics, and racial reckoning, and these are urgent issues in our country. So everybody acknowledges he's got to get a grip on those things. Secondly, the laws won't change, so the freedom of movement is limited. Third, there is an ongoing investigation of US personnel, and there's going to have to be some analysis of that and whether US complementarity is a way to address those issues going forward. And then finally, let's be honest, the court has its issues. It's personnel, they have personnel weaknesses, they have weaknesses in their doctrine. We all have discussed this and we have to be honest about it, and the administration would want to engage with them. So I think that the processes, a three-stage process you could envision is one, end gratuitous, outrageous adversarial acts like the executive order right away. They serve no purpose. They're entirely counterproductive. They stand in the way of a win-win situation. Secondly, have some consideration of the kinds of cases that the ICC should do with US support, which serve everybody's interest. We didn't have any better solution to Bosco and Taganda or with the ICTY. We didn't have a better solution on Karadzic or Milosevic than to bring them to the tribunal. So that this is exactly the reason why you want finding and identifying common interests. And then third, the Assembly of State Parties meeting, the first one that the US would reattend as an observer isn't until more than a year from now. And it might take as long as that to work out position. So I think that there will be a lot of people who will be screaming, how come Biden hasn't fixed everything instantaneously? And I think that would be quite unrealistic. Better to get it done right than to get it done fast and wrong.
Well, these were great presentations. Let me go to audience questions. I'm going to read 4 of them, and we'll do kind of a lightning round, and anyone can weigh in on any. The first one, can it really be argued amicus briefs account to material assistance? Well, let me point out these amicus briefs that we filed. I filed one. It was arguing to open the Afghanistan investigation. So, you know, these were all done before the executive order, which is not retroactive. I don't know if any others have further weigh in on that one. Gabor Rona asks us, Secretary Pompeo says the ICC action against Americans violates sovereignty. Since the US is not a party to the Rome Statute, is this true as long as the court limits its focus to ICC crimes committed on the territory of ICC states parties? Another question, what kind of work is US government doing to promote rule of law and domestic justice systems in the developing world? That should go for Stephen, but we only in a lightning round. And Ambassador Rapp has said a few times the US really holds our war criminals to account. Given the lack of significant consequences from Abu Ghraib, My and similar US military actions, do other panelists consider that to be a credible assertion? So I think we're gonna just do a lightning round. I'm gonna go Stephen, Beth, Harold, Clint, and pick any of these that you want to answer, keeping in mind we have 10 minutes total to wind this up.
I mean, we do have a system of military justice that works and holds people to account. It doesn't often reach people at the senior levels, it's true. We don't have the international law of command responsibility. There are aspects of our law that definitely need to be improved. I think the criticism that I have, particularly during the Trump administration, is the ways in which even efforts that we've done, like on the the Gallagher case of killings in Afghanistan, that these situations haven't been dealt with appropriately. We haven't allowed justice to work, and frankly, when it comes to complementarity and torture. The situation was we had an inquiry, or at least a special prosecutor appointed by Eric Holder, very secret investigation, eventually closed to look at that. No kind of public reporting, and a relatively limited mandate. Frankly, thereafter, we had this report from the Senate Intelligence Committee, 6,000 pages, which we never saw, 500 pages of summary, 6 million documents were uncovered. I think, frankly, to have complementarity, there needs to be a special counsel to review all of that and determine if there are cases to be made, and the person at the appropriate level that should answer for it. And so that's what's needed. If we did that, we wouldn't have any problem at all. I've said already that I think the ICC has territorial jurisdiction. This is not a question of US sovereignty. This is Afghanistan sovereignty. They are the ones that sent their criminal cases to The Hague. And when you go onto a country's territory, you can be held to account. Now, they can maybe not prosecute us themselves or allow us and not arrest us or whatever. But if we commit a crime there and then turn up in another country, we can be prosecuted. That's a principle that every one of the countries in the ICC subscribe to, and making the argument that there's no jurisdiction, I think is the wrong argument. It has to be, we've done justice ourselves, and we haven't yet and need to.
Thank you, Beth, but I'm going to throw one more question in the mix. It's in the chat function. What happens if the ICC prosecutor wants to go to the Security Council briefing? She has briefings coming up on Libya and Darfur. Will the US deny her visa, or and wouldn't that be a violation of the headquarters agreement? So I'll throw that in for anyone who wants to answer any of the 5 questions we now have out there. Yeah.
Yeah, maybe I'll just take a quick tackle of that one. Harold probably can weigh in as well. But my understanding of the headquarters agreement with the UN is that she needs to be allowed to come in. In fact, did come in before when she was under a travel ban under an earlier sanctions regime. And so as long as she stays within the headquarters agreement area and doesn't do any work beyond that, I think she's safe. Now, one thing to bear in mind is, we say that she's been sanctioned. What does that actually mean? She cannot use a credit card to do anything, right? As long as it's passing through somehow a US bank and is a dollar denominated credit card, she literally can't use a credit card. So you talk to people who've been under these sanctions regimes and they're carrying bags of cash around because they have to pay their hotel, they have to pay, et cetera. So my understanding is that there are some measures being put in place, and the Dutch government has been quite helpful in this regard to enable her to be able to function like a normal human being, even in her personal life, et cetera. But in terms of doing the briefing to the Security Council, as long as it's UN business, it's safe. Now, this does raise the question of whether or not the ASP were to go forward. It's now happening remotely, so we're not there, but would she have been able to come physically for the ASP, the Assemblies of States Parties? The ICC is not a UN entity. That meeting is hosted at the United Nations, but it's not necessarily a United Nations meeting, so it would have raised some interesting questions. We haven't had to jump that hurdle because the meeting has gone virtual, and many of the important events are going to be delayed a little bit until the new year, with the hope that the pandemic will be in a better place. I just want to echo what Stephen said, in that there are some elements of the US government that insist on making this sovereignty-based argument, and they want to stop the discussion there, that should be axiomatic, and as a result, there's no need to discuss further. And of course, if you've ever been a trial lawyer, you know that you want to deploy whatever arguments you have. And if you have an argument that's a principled argument that you want to preserve, fine, make that argument, but be willing to make other arguments that might be more valid or convincing or compelling. And I think the sort of broad-based legal argument that there's no jurisdiction over US persons because the United States has not ratified the Rome Statute hasn't convinced a single soul, including many people within the US government, including many lawyers within other agencies of the US government. And so we need to be willing to defend these actions on the merits. And that means looking at things like complementarity. It means improving our ability to make complementarity arguments. It means looking at issues of gravity, et cetera. There's many arguments on the merits that can be made. And by insisting on this sort of no jurisdiction argument, quasi-legal argument, I think it really eclipses and undermines our ability to deploy what would be ultimately more effective and convincing arguments.
Harold, I think we have a total of 5 questions floating around. Any of
Well,
contains.
let's face it, Mike Pompeo is the worst Secretary of State in American history, serving the worst president in American history. And Mike Pompeo's failures include the Commission on Unalienable Rights, the way he's treated the human rights policy of the United States. Now he wants to call Human Rights Watch an anti-Semitic group because he can't understand the difference between discrimination against a religion and disagreement with a particular government's policies. And with luck, he'll be looking for a job in 12 days. And I think that rather than fixating on him, I think the more important point is that the United States supports the rule of law. The United States supports human rights, and that means supporting the independence of lawyers doing their job. And we don't accept the targeting of lawyers and prosecutors domestically, and we shouldn't accept it internationally. That's the kind of thing that Erdogan does in Turkey and that they do in Hong Kong. And that's not the kind of thing that the US government ought to be using its coercive powers forever. And the idea that you would go after someone because they're writing a amicus brief in support of a legal position that they believe in is so outrageous and contrary to the values of a rule of law system. There should be bipartisan objection against that entire notion. But I think it's a measure, it's important that these approaches and arguments be delegitimated and that the actual win-win position be carried forward. Notice the way that John Bolton raised these issues in the George W. Bush administration, eventually left, came back, and managed to push them further in this administration, even while having a falling out with the president and having convinced Mike Pompeo of the correctness of these arguments. So even while Bolton is suing and being sued by this administration, his legacy lives on. Well, I think those of us on the other side of these issues have to be just as strong the other way and not let the dead hand of John Bolton rule our policy toward international criminal justice when a fair system of international criminal justice is entirely in the United States' long-term interest.
Thank you so much. Clint, you have the last word. But you have to unmute yourself.
Sorry about that. Okay. And based on kind of the tone of the conversation, maybe it won't come as a surprise that I'm going to beat up on the current administration a little more. Just two of these questions I'd like to take on. The first was this question about U.S. support for rule of law around the world, and particularly in the developing world. In the U.S. has, for many years, been the greatest funder of these efforts. The bureau that Harold headed during the Clinton administration, the State Department, Democracy, Human Rights, and Labor, does this. Other bureaus in the State Department, USAID. We expend tremendous resources, and it has always been a high priority for our foreign policy to support rule of law efforts around the world. I think President Bush, when he came into office, was very critical of this idea of nation building and everything. But the attacks of 9/11 brought home the need to create stability in distant parts of the world, because instability anywhere creates a threat to security everywhere. And so this has, I think, even gained traction with people who tended to be isolationists. But in this administration, they have cut back funding. This has not been a priority to pursue these efforts to bolster rule of law around the world. And I think we as a government suffer, and I think the security of the world suffers as a result.
And I think I have to cut you off here. We're right at 4:30, and I apologize so much. I'm afraid we're going to cut off. So this has been a very rich discussion. Thank you so much. There is an ICC breakout session in the next hour. It's held by the ICC committee of ABILA, and anyone with last questions is welcome to come into this. Thank you so much to the panelists, and I apologize that I think we have a strict stop at 4:30, and we have hit it. So thank you so much. Much applause, and thank you.
Thanks, everybody. Great to see you.
Bye-bye.
Thanks for your interest.